Arbitrators. He is also a fellow of the Chartered Institute, and I could go on and on, but I'll just do justice to him to say that he is very experienced arbitrator and has handled international arbitrations. And he is also active in the moods, the arbitration moods, the mediation moods, and all that has contributed significantly in that area. That is Aziz. Then I'll move on to Mr. Inbavijayan. Mr. Inbavijayan is an international arbitration and ADR practitioner since 2001. He is based in Chennai, India. He has handled hundreds of domestic arbitrations, and he has handled numerous number of international arbitrations. He is a registered foreign lawyer with Singapore International Commercial Court and also the United Kingdom and in Kazakhstan as well. So he's a person who is very familiar with international arbitration. And he's also involved in various universities. That is Mr. Inbavijayan. And last but not least, my good friend, Dr. Malcom, is from Jamaica. He was formerly the Attorney General of. Can we request the participant to switch off their mic, please, because it may impede with the program. Thank you very much. As I was introducing Dr. Christopher Malcolm, he was formerly the Attorney General of British Virgin Islands, and he is attached with the University Faculty of Law at Mona University of West Indies. He is the Secretary General of the Jamaica International Arbitration Center. He is an attorney at law admitted to practice in the West Indies as well as in many other jurisdictions, including British Virgin Island, Dominica, St. Lucia. So in case you are in the Caribbean, Dr. Christopher Malcolm is the person to look for. And he is also a very active arbitration and ADR practitioner. So he will be able to share very important and current development. So those are the brief introduction of your speakers today. So the way we will do it is this. As far as the topic is concerned, we will start with Mr. Aziz dealing with the issue of conflict of interest. Then Mr. Inbavijayan will deal with the issue of conflict of interest, especially with the Indian experience, Indian perspective. And we have Dr. Christopher Malcolm that will take us through the second aspect of the discussion, which is the issue of taking of evidence. So without further ado, let me invite Mr. Aziz to share with us his experience on that topic. So Aziz, the floor is yours. Thank you very much.
First of all, good morning, Dr. Malcolm. Good afternoon and good evening to everyone. Let me first say thank you to Dr. Shukor for giving me this opportunity of coming on, and of course to BicTok itself. When he sort of spoke to me some weeks back, said that he wanted me to speak on this, I sort of jumped on it and says, yeah, definitely, I mean, whatever I can share in that sense. Okay, I have prepared some slides. I think we'll just sort of go through these slides, and then what I will do is along the way, I will sort of give my impressions of what I feel, that I think in my personal view, that there's certain disagreements I have in relation to what could be considered as to whether there is a conflict or otherwise. So that's basically what I will be talking about. But let's move on with slides now. I think, can we just have the first slide? I mean, it's just basically just to explain to you all that, you say, for me, I think everyone here knows that, when we go to court, I mean, we actually can't choose a judge. But the position is that we don't definitely want a situation where the judge who's hearing the particular matter, as far as the parties are concerned, he has to be impartial as well as, of course, at the same time independent. Well, now bearing in mind that in arbitrations itself, it is the parties who have in fact agreed to arbitrate. More so than I think this point about impartiality and independence comes into play. So that's basically what I would say. Now, can I move on to the second slide, please? Now, just as an introduction quickly, I think it's important that for the parties concerned here, I mean, or other participants here, go into the IBA guidelines itself. I mean, you can check this out, but I'm just sort of summarizing this when it was first sort of introduced, and of course the amendments have come about in 2024. But you can see, one thing you will notice about this is that I can understand where IBA comes from in that sense, because no matter what you do and whatever you say, there cannot be a situation where it covers everything completely. All right. And I'm sure along the way, certain scenarios will occur where certain amendments in future will have to take place. Now, can I have the next slide, please? Okay. Now, as we can see this, now basically what's important to note is that these guidelines do not override anything in terms of national law, arbitral rules, or codes of conduct. I mean, we all know that UNCITRAL itself has got their own rules in a sense, right? But what is important is that these guidelines are there for parties to follow, because it is a fact that nowadays courts have in fact been referring to these guidelines. So it is, in that sense, you can consider it's like a soft law, but nonetheless, national law, of course, overrides. If there's anything in the act itself, and of course, then this sort of, takes a second seat kind of thing. Can the next slide, please? Okay, now you will note that as far as these guidelines are concerned, I've highlighted this. Sorry, can you hear me?
It's all right. I think it's just
Okay.
interruption, Aziz. Thanks.
Okay, sorry, my apologies. You can see that I've highlighted these two words called impartiality, independence, basically because that is basically the fundamental thing that one has to remember in relation to the conflicts of interest in relation to these IBA guidelines. Now, as I said earlier, it can never be totally exhaustive, yeah, and it should be considered with common sense, and at the same time cannot be unduly formalistic in the sense of the word. Now, can we move on? Okay, now, one thing that I think I want to sort of emphasize is that in a situation where if you have a question mark in your mind as an arbitrator, who is, when you're appointed, or even from the point, let's take it from the party's point of view, it is always okay to ask for the arbitrator concerned to disclose. Because what is important is one must take note that disclosure itself does not mean that you're conflicted. That's all. So basically, whenever there is a question of doubt, my take would be disclose. The word disclosure should be paramount in the mind of a person who is appointed either by the institution or by the parties concerned. Yeah. Can I have the next slide, please? Okay. Now, these general standards, I have not sort of given I have not printed, put it on the slide in a sense, but I think it's important that you go through these principles. There are basically 7 of them. It's all covered in the IBA guidelines concern. Now, and it's actually divided up into these 7 categories called general principle, conflicts of interest, disclosure by the arbitrator, waiver by the parties, scope, relationships, and duty of the parties and the arbitrator. Now, what they have done is, bearing in mind these principles that they've in fact spelled out, then what they have done is to create lists, because we all need certain what is called guidelines as to what we should be doing in certain scenarios. But like I said, this can never be exhaustive. So, it's a situation where sometimes it's a situation where you must, it's like more like a touch and feel kind of scenario. That's the reason why I've always emphasized that if in doubt, disclose. Can I move on? Okay, this is where you all can get the full, in a sense, can be downloaded, the guidelines concern. I'm sure most of you all have done so before. Okay, can we move on to the list concern now? Now, you see, basically, the applications of the standards is basically very simple. What the IBA has done is they've created what we see in like a traffic light scenario. They call it, the application lists are divided into a red list, an orange list, and a green list. Now, but again, as far as the red list is concerned, it is subdivided into a non-waivable red list and a waivable red list. Now, of course, as we move along, I'll be sort of emphasizing certain things which like I said, there are certain of these are my personal views, which you may or may not agree with, and something that, of course, we can discuss in a question and answer session later. Now, as far as non-waivable list, the red list is concerned, this would mean what is called, it is totally incurable. What it means is that basically, in a situation like this, which I'll show you the examples later, the 4 such scenarios, is that even if the parties agree that, hey, it's okay, we want this particular arbitrator, is a no-no. Basically, this is what the IBA guidelines are all about. It's a situation where the parties also therefore have to respect the fact that once you come within these 4 scenarios, the person cannot be appointed as arbitrator, and the arbitrator cannot accept the appointment concern. That is a point here. Now let's look at the first scenario. Now this scenario there's an identity between a party and the arbitrator, or the arbitrator is legal representative in the arbitration, or employee of a person or entity that is a party in arbitration. Now, basically, that means what is emphasizing here is in this first scenario, there's like a link between the party and the arbitrator. What that link can be, anyone's guess, right? But basically, depending on the factual scenario at that point of time, when they say that an arbitrator is appointed, one is to consider that. So in this kind of situation, like I said, emphasized earlier, it is incurable. It is not for the person to accept an appointment, as well as not for the parties to even agree to an appointment. The second scenario would be the
Sorry,
arbitrator is a
just
man.
interruption,
Sure,
Aziz. Right.
sure.
Go ahead.
My apologies. The arbitrator is a manager, director, or member of a supervisory board, or has a controlling influence on one of the parties. Now, sometimes it can be a situation where a party is like a corporate kind of body. There's a supervisory board kind of thing, whatever it is. But it is, you can see the language is in a very broad sense, yeah? Or has a controlling influence on one of the parties or an entity that has a direct economic interest in the award to be rendered in an arbitration. Now, I think in a situation like this, it is so clear, right? That come on, how can a person ever accept an appointment like that? Because it's a situation where if you have an economic interest, then it follows that, I mean, there's no way that even the parties can agree, and for that matter, the parties cannot, like I said earlier, emphasized, cannot agree to that kind of appointment. Third scenario, please. The other one is, of course, some of it does overlap. The arbitrator has a significant financial or personal interest in one of the parties or the outcome of the case. So it is the same thing, like, in that sense, outcome, it has got quite a similarity to the second scenario earlier. Can we move on to the fourth scenario? The arbitrator currently or regularly advises a party or an affiliate of a party, and the arbitrator or the arbitrator's firm or employer derives significant financial income therefrom. Again, economic association. Now, so in these 4 scenarios, as I mentioned, this is what is called a non-waivable red list. These are the situations where an arbitrator cannot accept, and the parties cannot derogate from that also. They cannot, in fact, agree to such an appointment. Now, let's go to the non-waivable. It should be non-waivable now. Oh, sorry, my apologies. My apologies. Now, let's move on to the waivable red list. Now, if you look at the waivable red list, you will see that this covers cases may be serious but not severe. That's what the guideline states. Now, in this kind of scenario, it will seem that when the parties agree and being aware of the conflict of interest situation, they can in fact agree that an arbitrator can appoint or accept an appointment, because they themselves want that particular arbitrator, provided, like I said, again, it does not come within a non-waivable list. And in this particular situation, it is, of course, advisable for the arbitrator concerned to ask that the parties not only agree, but it be put down in writing, because he doesn't want his award to be challenged based on this fact itself. So can we move on? Okay. Now you will see this, the situation here is one of them appears as, it's listed as 1. Arbitrator is given legal advice or provided an expert opinion on the dispute to a party or an affiliate of one of the parties, or the arbitrator had a prior involvement in the dispute. Okay, so in this case, it's a question mark as to whether the parties want to agree or otherwise, right? Okay, but disclosure, like I said, is of course paramount and important. Now let's move on. All right. Now, under this list, if you look at A and B, I just want you all to consider this and ask yourselves, can parties agree to such a situation? The answer, obviously, it would seem that if you follow the guidelines, yes. But shouldn't, in my personal view, again, like I said, shouldn't this kind of situation be actually in a non-waivable list? Because here it says the arbitrator holds shares either directly or indirectly in one of the parties or an affiliate of one of the parties, this party or an affiliate being privately held. Now, just like we know in the situation where judges, example, some of them may hold public listed shares is one thing, but if imagine if they're a director, or in I said they agreed, it's in a situation, some jurisdiction they may have a situation where they can that particular person be hearing a matter where a party is involved? So there's a question mark. Similarly, for a B, if you look, a close family member of the arbitrator has a significant economic interest in the outcome of the dispute. So to me, this is quite fundamental, because I don't understand why, in the wisdom of the IBA concern, this comes under the waivable red list. I mean, this again, like I said, is a personal opinion. People can question this, right? But okay, if you look at C, okay, fine. It may be slightly different, and I'm sure you all would have a close look at it earlier. Now, can we move on again? There's a second list under the waivable red list. Now, this is in relation to the parties of the counsel. Now, you will notice that what I've done is in something which is in bold. Again, I am raising question marks, but whether this actually can be a scenario where parties can actually agree. And I'm emphasizing for the participants to look at B, C, and D especially, and of course at the same time at F. Now, all these, of course, are in the guidelines concern, but if you look at this, the provisions here, to me, I feel red flags are there, right? I mean, it's quite obvious. But yet, as far as IBA is concerned, it would seem that these are waivable, comes under the waivable list, and it's for the parties to decide as to whether they want the particular arbitrator to carry on arbitrating in the matter. Okay, so it's like I said, it's to each his own, but the reason why I flagged this is because when I read this, I had different thoughts about this matter. Okay, carry on, another list. Now, you will see under the orange list, we are now moving on to the orange list itself. Okay, this is for service for one of the parties or other parties involved in the case. You will see that as far as these items are concerned on the A, B, and C, if you can have a quick look at it, which again, like I said, these are things that one can read when one downloads the entire guidelines. There's a situation where I think it seems to be quite okay in a sense, right, for the parties to be able to agree in relation for the arbitrator concerned, but that does not detract from the fact that the arbitrator concerned, when if he's appointed and if he comes within one of the scenarios, he has to disclose. Disclosure is always paramount, and a mandatory thing. Okay, shall we move on? Okay, now similarly, if you look at the next page now, it's okay. You will see now, I have highlighted again this para E. Now you all can take your time to look through this, but if you look specifically at para E as well as subpara H, the question then arises whether this should in fact even be in this orange list, or should it be in a non-waivable rate list, or for the matter, a waivable rate list. Because to me, it's a situation where, economic interest again comes about. I'm just going to pause here for a little while for you all to have a look at these subparagraphs E and F, H, but we can always, of course, recall back these slides and, when we have these question answer sessions. Okay, can we move on to the next slide, please? Yeah, again, in relation to the relationship between arbitrator and another arbitral counsel, there are certain rules have been mentioned, certain guidelines have been given. What I've done is, again, highlighted in darker color, A and B, as you can see, where I'm raising certain questions in relation to whether they should be in this list or somewhere else. All right, and you can see that as far as A is concerned, the arbitrator and another arbitrator are employees in the same law firm or have the same employer. And the arbitrator and another arbitrator or counsel, one of the parties are members of the same barristers' chambers. Yeah. So I leave it to you all, but these are basically the guidelines that's been provided. But I'm just wanting to highlight this because I want the, whoever is attending here to be able to think about this and tell me your thoughts later if you have any. Okay, can we move on? All right. Similarly with E, F, G, and H. This is a relationship between arbitrator and another arbitrator or counsel. It goes on. Now you will see, especially F is concerned, a close personal friendship exists between an arbitrator and counsel of a party. Now, in a situation where we all know, especially in even like say a country like Singapore, I know most of the lawyers, especially the senior ones. When I'm appointed, of course, I'll disclose that I know the lawyer as long as I do not know the party concerned. But the problem is when you talk about knowing a counsel is one thing, but imagine if, say, you have a situation where you actually have some sort of an arrangement where you know the person so well that it's like a different kind of a bond, then the question would arise as to whether you should even accept that kind of appointment in the first place, right? That's what I'm raising this. And the other one is in relation to G. Enmity exists between an arbitrator and a counsel appearing in an arbitration. Now, if you really don't like the fella, now can you actually be able to say that you're going to be independent and impartial? So that's a question one has to ask, all right? Okay, so can we move on now? Sorry. Okay, this basically is the third list, yeah? On the second list, sorry, the relationship between arbitrator and another. These are all the various scenarios. You can have a quick look. Okay, can we move on to the next list? Next. All right, now, under the orange list number 3, you'll see there's a relationship with the arbitrator and a party and other parties, sorry for the spelling error, involved in arbitration. Now, if you look at A, which has been highlighted, and if you look at C and D, as far as C is concerned, again, this issue of economic interest. Similarly with D. But if you look at A itself, it actually says arbitrator's law firm is currently acting adversely to one of the parties, or an affiliate of one of the parties. And that particular, you see, question mark then. The question can arise is this. Is an arbitrator just an employee? Is an arbitrator a partner in that firm? Meaning, if the partner means, is he a senior partner? Is he a junior partner? Whatever. But the point is, it doesn't say that. The guidelines do not state that. It just says the arbitrator's law firm is currently acting. So different scenarios may arise. I think a situation can be like, say, especially if the person, the arbitrator concerned, who is appointed, is actually, say, a managing partner or a senior partner. It may be slightly different from, say, if the person is just an employee. I mean, these are things that I think one has to consider, right? Okay. Okay, can we move on to the next slide now then, please? Okay, these are the other circumstances. Now, if you look at the other circumstances again, there are only 4 such scenarios, yeah? 4 such, situations there. Okay, but I've again highlighted B, because it says here the arbitrator has publicly advocated a position on the case, whether in a published paper or speech through social media or online professional networking platforms or otherwise. Now, the question now will be this. If, assuming you have advocated a certain position in relation to a similar kind of factual scenario appearing before you, should you even accept that kind of appointment in the first place? Leave aside having to disclose. I mean, these are things that I think one has to consider, right? Now, can we now move on to the next list, please? Okay, as far as green list is concerned, this is supposed to be a situation where you have the green light, that's it, you're okay. So here is a situation where it says arbitrator has previously expressed a legal opinion such as a law review article of arbitration concerning an issue that also rises up. But this opinion is not focused on the case, is a different scenario. Okay, let's look at the second option, second scenario. It says very clearly that even though it is the person is, there's some kind of, there's an alliance there, but it doesn't share significant fees or other revenues or arbitrator's law firm, and rent services of one of parties or affiliate in an unrelated matter. So you can see that, if there's a direct economic kind of scenario, is again a different scenario. But if something that's lesser, then it should be okay. Let's look at the third scenario for the green list. Okay. These are the 4 different situations where contact with another arbitrator or counsel for one of the parties. Now, again, like I said, although it may provide that a situation in any of these situations, an arbitrator can act, but it does not mean that the disclosure is not important. So always err on the side of, of caution and disclose. Yeah, and I think that basically ends my talk, or rather my presentation for this purpose. All right. So, I mean, I just want you all to, but sorry, there's one more slide. I forgot about this. Now, there's a contact between the arbitrator and one of the parties concerned. Now, if you again look at this, the situations are such that basically, again, the emphasis will be disclosure, but the situation is such that one can appoint, but having disclosed and without none of the parties doesn't raise anything, I don't think so. This can be raised again in a situation where if the person wants to try to sort of set aside. Now, having said this, I think the point that I'm impressing here is this. You must understand that when you are appointed as an arbitrator, you don't want to be a situation where, imagine tomorrow, the party that is, of course, is not happy with the award made against, say, either the claimant or the dismissal against the respondent or the claimant's claim, and the other party wants to set it aside and raises bias against you. And of course, if the court finds that, then is it going to be a problem? Similarly, I think you must understand that when one sits as an arbitrator in an arbitration matter, the whole idea is that you want to make sure that the award that you, in fact, do subsequently write and publish has to be an award which can be, in fact, taken by the party that succeeds to be able to sort of obtain the fruits of the award concern itself. Thank you very much. I don't have anything further. It's for that.
Thank you, Aziz, for
So there's
giving
one more.
the
Sorry. Yeah, there's one
yes,
more. Yeah. It's okay.
right.
Right. Thank you. Basically, this is, yeah. This is very clear.
All right. Probably we can stop sharing of the screen.
Yeah,
Thank you,
Sorry
Aziz.
if I exceeded that time. Yeah, right.
Yeah, no problem. Thank you, Aziz, for the talk, for elaborating what I would call the traffic light systems. The red means stop, the orange, be careful, and green is good to go. So we have the traffic light system that is introduced by the IBA guidelines. Now we will have Inbavijayan, who will then explain further on this traffic light system. Without further ado, I give the floor to Inba. The floor is yours, Inba.
Uh, Thank you, Dato Shukor. Uh, Before commencing, I like to just thank Mr. Aziz for giving a wonderful insight about the IBA guidelines on conflict of interest, particularly all the three lists. It is very interesting that this soft law, which is commonly used in the international arbitrations, particularly in the perspective of arbitrators, India is one jurisdiction where it has been adopted as a mandatory provision in the arbitration legislation itself. As an information, the Arbitration Constitution Act 1996 of India got amended in 2015, and obviously it came into effect in 2016. It was very clear that three schedules was included. It is not like this red or the orange or the green list. They had a different perspective. They brought in three component, wherein one component, obviously it is a combination of red and orange list. There is a fifth schedule. Next, we had a sixth schedule wherein the law itself provided a form or a template for a disclosure or a declaration what an arbitrator has to give in an ad hoc arbitration. Third, they brought in exclusive red list. All these three schedules, which is based on these IBA guidelines, very interestingly,
Sorry, Imba, can I request all participants to switch off the mic so as not to interfere with the talk? Thank you very much. Imba, you can continue. Thank you.
Very interestingly, these three schedules, which was included in the Indian legislation of arbitration, has clarified what is the limitation of an arbitrator when it comes to relationship. All these amendments, which has been brought in the IBA conflicts of interest, the recent amendment, what Aziz was mentioning about the social media relationship, which comes within the green list. Still, the aspect of compulsion, which is the culture embedded in most of the subcontinent, the compulsion has made this arbitration to a reasonable level, adopting this IBA guidelines. This is some basic opinion what we can have on these particular IBA guidelines applicable to the arbitration practice in the subcontinent. Can we move on to the next slide? Fine. This is a small narration about what IBA wants to do, which the earlier mentors guided this to be a soft law. No doubt, most of the jurisdiction, it is considered to be soft law, but still, it obviously encompasses a wide range of guidelines, particularly covering the legal ethics, the professional conduct, and the best practices in various areas of law. No doubt on it. It is giving the best practice. And as arbitrator, fortunately, in India, the law also has developed in the way that there is a regulator captioned Arbitration Council of India, which also deals with empanelment of arbitrators and grade the arbitration institution. Anyway, it is a beginning stage of its functioning. But still, these regulators, which have already provided certain ethical or the professional standards for the arbitrators, this IBA guidelines happen to be a pioneer encompassing the quality as well as the integrity of the legal as well as the arbitration services. It's very clear. Can we move on to the next slide? Okay. These are the 5 fundamentals, what we can take from these guidelines. In a perspective of an arbitrator, ethical conduct, the accountability, technically it is an accountability, but the slide shows that it's a professional responsibility. The internationally best practices, the adaptability, and obviously the impact. All these 5 happens to be the valuable components of these guidelines. And as an arbitrator or practitioners in arbitration, if you can seriously look upon these guidelines on these perspective, we can be cautiously dealing with arbitration, and no doubt the arbitral award, whether it's a domestic or the international or the foreign awards, might have a limited opportunity to be tested by the courts. Can you move on to the next slide? Yeah. As a matter of repetition, if you see the standards which has been given as a green, orange, and red list, most of us would have the expectation why this list is being given and what for the traffic system has been facilitated in arbitration. As arbitrators who are acting as private judges, we do have certain protocols. I think most of my colleagues would accept the Chartered Institute of Arbitrators protocols on conducting the arbitration proceedings based on the UNCITRAL, one of the another soft law, the UNCITRAL notes on organizing arbitration proceedings, all gives a guidelines how to conduct the arbitration proceeding, but there is no clarity on how an arbitrator has to act when it comes to his responsibility and liability, or including the accountability. Can you move on to the last second slide? Little bit the next one. Yes. Okay. This is a slide what I'm going to focus for another 7 to 8 minutes. In 2014, we happened to see certain developments in the guidelines which India wanted to take. And technically, there are 34 categories of relationship based on the standards, 34 categories. And in the 34 categories, 1 to 19 are considered to be in the red list. India has one jurisdiction. It is very specific that it is not going directly the understanding of non-waivable or waivable red list. It is very clear that 1 to 19 cannot be waived. It's non-waivable red list. Certain reservations are there, but clearly the applicability of these categories are very clear. And for us to understand, it has been made to the extent where the interpretation is very clear. If the arbitrator disclosure comes within these 1 to 19, they are prohibited to act. They cannot be appointed as an arbitrator. That's well settled. And further, if you just go on to the component of the declaration, what has been guided, there also we can literally see the aspect of relationship, what has to be disclosed. India has gone beyond the understanding of IBA guidelines on conflict of interest, wherein the 6th schedule gives a particular declaration in quotes, circumstance disclosing any past or present relationship with or the interest in any of the parties or in relation to the subject matter in dispute, whether financial relationship, business relationship, professional relationship, and it doesn't stop there. Very interesting thing is that, or other kind. Various aspects of relationship has been brought in within the ambit of the declaration what an arbitrator has to disclose. This is the aspect of conflict of interest. And to add on, there is a time frame also given to the arbitrators wherein the conflict of interest is being modified to the extent that if the arbitrator has many number of ongoing arbitrations, they can't find a reasonable time to focus on that particular case and complete it within the time frame given under the Indian law, that is the 12 months time frame. It has been developed to that level that not only the relationship like financial, business, professional, or any other kind, it is also the onus is on that arbitrator to look upon the contribution, particularly the time, what he is going to spend for that arbitration, so that he can at least complete the arbitration within the 12 months for the domestic arbitration. International arbitration has been exempted. This happened to be facilitated by an amendment in the arbitration law in addition to the schedule, particularly when we read Section 12 of the Indian Arbitration Constitution Act, Amended Act. They have included one subsection 5, wherein it reads, notwithstanding any prior agreement to the contrary, that is very important for non-waiver, any person whose relationship with the parties or the counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule, that is 19 relationship, shall be ineligible to be appointed as an arbitrator. It's a clear mandate, a declaration. If it comes within the categories 1 to 19, predominantly the red list, then that person who might be the prospective nominee as an arbitrator, whether it's a co-arbitrator, the presiding arbitrator, or even sole arbitrator, shall be ineligible to be appointed as an arbitrator. The proviso is there, but literally the courts have settled the issue that once the arbitrators are within that ambit of 7th schedule, which is the red list in the Indian law, cannot act as an arbitrator, or it is simply read out as ineligible to be appointed as an arbitrator. Very interesting development. And if you look on this particular amendment in 12th section, this also incorporates the 3 list of relationship between the arbitrators and the counsel by way of what do you say, to avoid confusion in interpreting the section. To add on, as an arbitrator, in most of the personal cases where we happen to get involved in much of these domestic as well as some international arbitrations, the arbitrators are not only going to disclose whichever comes in the orange list, that is beyond 19, that is 20 to 34 categories given in the 5th schedule, which is including the orange list. The arbitrator has to very well relinquish the position, or they might be challenged, and that challenge eventually ends up with the appeal provision in the Indian courts. Unfortunate. This should not happen, but because of this amendment, we do have an opportunity for that arbitrator's authority to continue beyond the challenge subject to his decision. No doubt, this IBA guidelines on conflict of interest, with adoption of the original version, the amended 2014 and the recent 2024, which interestingly bring in all the social media network and the connectivity, the contribution, what we are giving as a public opinion or a lecture, it's all making the role of an arbitrator quite refined. And this reform is very well acceptable when we do have the compulsion culture in our legal system. If our legal system is very clear to accept this compulsion, forget about the mindset. The mindset when it comes to the arbitrator's perspective, before these guidelines are considered to be a soft law instead of being brought in as a mandatory provision, the country which adopts, which has a culture of mandatory statutory stipulations, no doubt this is facilitating the best standard of the arbitrators practicing in such jurisdiction. These are some points what I wanted to highlight. Thank you, Dato.
Thank you very much, Imba. I'm sure the participants are enlightened that the Indian jurisdiction has decided to go beyond the IBA and has adopted a listing procedure in the sense that, they have listed far beyond what IBA has provided in terms of guidelines, perhaps we can discuss as to whether that is something that other jurisdiction ought to follow. Probably we can have that in mind in our discussion. With that, I now move on to Dr. Christopher Malcom, who will now deal with the second aspect of our discussion, which is the guidelines on the taking of evidence. Yes, I will give the floor to Dr. Malcom.
Good evening, Chair, and to everyone here involved. And I must thank Aziz and Inba for their earlier presentation and the way they defaulted from those rules on conflicts of interest, the guidelines rather on conflicts of interest and where we're at. Now, what I'm being asked to look at today is the rules on taking evidence in international arbitrations, and I'm looking at it, as I say, in a perspective from within the arena of combat. There is I'll move firstly to the introduction, which is the third slide. If you could move to it for me, please. But before getting there, and in light of some of the things that were already said, there's a case that went to the Privy Council. You can move beyond the abstract to the point of the introduction. You can stop with the introduction for the minute, please. But there's a case that came out of the British Virgin Islands, went to the Privy Council in 2009, and I like to speak about it, Texan management. A couple of my friends appeared in it. But the very first line in that case reads, and I just pulled it up again, it has been said that in the pursuit of justice, procedure is a servant and not a master. And that case, I can assure you, has been of tremendous help to me in many matters in which I've appeared in court and elsewhere. But the reason for my starting there as a point of departure, notwithstanding it's not in the slides that you have there, is that as we're talking about the IBA rules relating to the taking of evidence, we need to remember this. One is that they're introduced when they are, not as soft law as happens in relation to conflicts of interest or in any other way, but they are introduced when they are because the parties specifically agree to them being accepted. And once they agree to those, they become part of the contract relating to how the proceedings are to be managed. And that establishes a very clear basis for the arbitrators acting in accordance with them. But even so, notwithstanding this acceptance of them, an arbitrator in any matter must still determine how those rules are to be applied in a practical sense, because the rules, however expansive they may be, once you get into fine application in an arbitration or in any other litigation or other proceeding, you will always have nuanced situations that will require the application of good common sense to ultimately get to a point where you need to determine where to go forward in the best interest of justice, which is where Texan management, that first sentence, and if you read through the judgment, it speaks clearly to that, about ensuring that you bear in mind what the ultimate objective should be, which is the pursuit of justice, whatever that is determined to be in a particular case. So if we go to the introduction, which is the third slide, I will take us to a few things there just by way of again, context. Now, one of the things I want to be clear about is that the IBA rules on the taking of evidence, they have become ubiquitous in international arbitration and almost as well used in many domestic arbitration matters as well, even though, as I've said, they come about by way of the parties contracting for them. Now, the reason, again, why that becomes important, if you look at, and it's mentioned in a further slide down, if you look at how these rules developed, certainly starting back from the 2000 and the 1999 rules, they came about through an original working party. And it is critical to look at it, to realize that it was really a group of Western European and US persons who were involved in developing the original set of rules. And if you move beyond that to the rules that the subcommittee in 2009, 2010 rather, that came up with 2010 rules, you will realize that there was an expansion to include there in that subcommittee persons from Canada, Colombia, China, South Korea, and so on, who were involved in that that further working group. And by the time you got to the 2020 review task force, this was expanded to include representations from India, Poland, Nigeria, Russia, Romania, and Egypt. And that context is critical because as we look at them and we look at how the persons are who have been involved in the development of the rules, we realize that for the most part, the developing world, countries in the developing world, Jamaica included, have never been at the table in how those rules have been developed, and how they are typically applied. And I say that because in the context of decision making, much as there are objective standards that you want to have in terms of how things are done, you will nevertheless have cultural, sociocultural, and other nuances that could affect how matters are managed. You know, I give a very brief example here. A colleague of mine was in the Privy Council arguing a matter, and they were speaking about one person moving from one yard, Y-A-R-D, to another in a confined space. And their lordships in the Privy Council just could not understand the context. And they literally had to go to the High Commission. They took a break in the proceedings. They went to the Jamaican High Commission and then got some explanation given as to what was meant in the context of Jamaica. And that had significant bearing on how it is that the Privy Council, their lordships, were able to understand evidence and how it was led and why it mattered in that context. So one of the things I say again is that as we get there in dealing with these matters of taking evidence, we need to bear in mind that we need to be sensitive, socioculturally sensitive in how we manage them. Another thing, of course, and Aziz mentioned that earlier, and I will not go through that, is that the rules are there and we need to read them. We need to understand what they say. But unfortunately, I've found that even where rules are agreed to, including on the taking of evidence, it is not unusual that those persons who have agreed them, the lawyers, not so much the arbitrators at this stage, may have agreed them without taking the time to properly understand them and what their implications for application are. So the one note I'd wish to make here is that as we're thinking about them, we also take some time to look at the rules and how they apply. And when you look at the rules, I think they're fairly well structured, and they start out, and if we look at how they apply, if you look, for example, at Article 1, the scope of the application, it tells you, you know, that those rules are there. And if I just look at 1.1 for the minute, it says, whenever the parties have agreed on the arbitral tribunal and the arbitral procedure has determined to apply the IBA rules of evidence, the rules shall govern the taking of evidence, except, and this is important, to the extent that any specific provisions of them cannot be effectively relied upon in the circumstances. That's a short of what is there. So again, the rules, I think, have sensibly allowed for some level of flexibility. And we need, again, to bear that in mind. So again, they're not static, and we need to understand them in that context. Now, the other thing that I wish to bring here, and this is a context which I want to explore a little bit, is that while we're looking at the rules, we again need to think back, as lawyers we do, to the mischief rule of interpretation, even though it's a statutory interpretation context that would be looking at. But the important thing to bear in mind is that when we're looking at the rules of taking evidence, what we're significantly concerned about is how it is that we can use the rules in a manner which will reduce cost and will lead to greater efficiency in the proceedings and greater certainty as well as to what it is that is to happen at specific stages. So while it is that we're concerned about what the rules say and how they apply to expert or fact witnesses and so on. I think it is important for us to bear in mind that we're not doing it for the sake of doing it, but we're doing it hopefully in the best interest of the proceedings and in the best cost and efficiency interest of the parties, of course. Now, one of the things to bear in mind again on this is the fact that arbitration is by its very nature, as we know. And if we skip to the next slide, which is on arena of combat, and you can go through, I'm not there, we make some very general statements that are applicable, but again, related to what I've just said. One of which is that the process is adversarial, but it need not be about fighting about everything. And in that context, the arbitrators must sensibly do what is required, as must the parties, frankly, bearing in mind that it is not about us as the lawyers or even the arbitrators. It's about how it is that we're going to be able to pursue justice in the best interest of the parties. So I then move to the slide which says cost drivers and their management, which is 2 slides from this one. And again, I'm focusing, as you would have seen, back now into the idea of the rules on taking evidence in a much more expansive way, really, by reference to a more narrow cost implications question. And one of the things to remember is that costs begin to accumulate in proceedings from the moment the agreement to arbitrate is crafted. There's a cost implication to that, and everything flows from that. Now, the terms of the agreement, therefore, is itself a cost driver. And whether we agree to apply the IBA or any other rules should be determined by reference to how are they going to minimize time, effort, and cost. The beauty of the IBA rules is that because, as I've said earlier, they're ubiquitous and people tend to know about them and tend to want to apply them. What the cost implication for this is that it prevents unnecessary haggling over what rules to apply, which sometimes in the context of arbitrations can take a significant time for the parties to agree specifically what they want, how the rules are to be applied on taking evidence, and what is to happen. By applying the rules, notwithstanding their inherent limitations, once the parties agree to them, you now find yourself in a position where that cost element of trying to waste time to figure out what to do is already settled for you. So you can move beyond that in a critical way. The other thing to bear in mind, of course, is that ideally, in relation to these rules, whether you adopt them or not, ideally you want this to be settled from the outset of the arbitration, and sometimes even at the point that you are agreeing to the terms of the arbitration, even though that is not sensible, most of us would say. But what is clear, however, is that at the very latest, in my view, we should try to settle upon those rules so you can move forward with clarity, knowing exactly what it is that the parties are about and how it is that they're best able to move the process along to deal with that. Now, again, getting back to cost, and if we move to the next slide, cost management and their drivers too, we will see here that I've mentioned, not one slide following that failure to undertake an appropriate cost-benefit analysis at critical points is going to be a problem in the arbitration if we're not careful. We have a tip of applying the rules and introducing them. We must think of what it is that the problem may be in relation to their application by reference to cost. Now, in relation to this management, there are a couple of things which I want to just mention here as being factors for us to consider when we're thinking of them or anything else for that matter in arbitration. The first I normally like to speak about is that we need to recognize that they're horses for courses. If the horse is trained for 8 furlongs and you try to get it to run 16, it is going to break down. So we have to be mindful in that selection that we're effectively choosing what is manageable for the parties without unnecessary cost implications and what should suit the purposes best. Clearly, in the context of international arbitration, costs tend to be a little higher, generally speaking, than they would be in domestic arbitrations, and parties tend to want to default to things they agree and understand, and the IBA rules tend to fit fairly well into that context. The other thing, of course, is to consider how, if at all, application of the rules could lead to unnecessary process or other delay. And if it is that it will, then we need to either eliminate it or to make appropriate adjustments in how it is that we apply them to reduce this possibility and by extension, addition of costs. And of course, the other things to bear in mind here is that as a tip in relation to how we choose is to always avoid reliance on square pegs being planted in round holes. And again, the rules are no different. The taking of evidence may well be perfect for one situation, but not for the one that you're dealing with. So don't, again, be a slave to saying, well, the IBA rules is what people tend to know, so let us apply it. Not necessarily what is the best in the interest of your matter. And so we need to go there. The other thing, if we move to the next slide quickly, is that, and this again is a question that tend to dog us a bit in arbitration. We tend to take our legal hats to it for those of us who are lawyers. Now, one of the things here is to remember that lawyering without focus, including where the lawyer, the lawyer or jurist is arbitrator, is a major cost driver. We have to bear that in mind as we're thinking. The consequential problems, of course, include our result from, again, the adversarial nature, which we sometimes have to try to prove our superior intellect or capacity. Again, not about us. It's about the parties and what is in their best interest. Then, of course, the inability to, or failure to disengage from how litigation functions when involved in arbitration. Again, what we have seen, and I've seen it happen, certainly in domestic arbitration, is that there are former judges and so on acting as arbitrators. And even though the parties may have agreed the IBA or other rules, in their own minds, they're reflecting to how things happen in courts and defaulting to that naturally, which could become problematic because of mindset. So we have to desensitize ourselves sometimes from what we know and re-engage the process of what we're trying to achieve. The other thing, of course, is the inability to engage, as I said, in relation to litigation and how it functions, to disengage from that, and sometimes forgetting that arbitration is driven by party autonomy. What do they need in the circumstances? Yes, the rules may suit us fine. We may know them perfectly, but is that what the parties require? And is that what we should be giving to them? Then, of course, the other thing is pride and its implications. We very often are prideful, many of us, and we tend to take what we know and how it is that we believe things should be done with that in mind, sometimes to the detriment of our clients. There's something else if we move to the next slide, which is about cost and value. Now, one of the things we tend to do here is we look at the next slide, not that one, the next one. Cost and expense, which often is looked at in the context of dollars and cents, right? Or whatever the currency is. Now, this, of course, delay, including by reference to how evidence is managed, is not usually explored with any real vigor where this is concerned, right? And the truth is that if we sometimes look at it, adds up and racks up costs. So the question again becomes, in applying those rules or taking them on board, are we, without even thinking, bringing on an additional cost element that we haven't properly considered? But where, however, the question of expense and cost arises, as I've said, we need to remember that arbitration is not really about whether it's cheaper or not. It's about what is in the best interest of the parties. So there is, in fact, a balance that we have to ensure that we keep of remembering that while we're trying to manage costs, we also want to ultimately have an award delivered, which is capable of being enforced and is not capable or susceptible to easy challenge because of how the rules were managed. Because we recall in this context that arbitration awards are easier to have them set aside on the basis of procedural irregularity. Generally speaking, that's where they are, rather than by reference to whether the substantive rules of law were properly applied. So, and in that element, the question of how evidence is treated with its procedural and adjectival implications will very often establish clear bases for challenge, if not properly managed in relation to how the proceedings are conducted. Now, if we go to the slide, and I'm closing off pretty much in two, we go to the next slide about looking at a story from within the arena of combat, as I have it slated there. Now, in Jamaica, we have a saying that gone bad a morning can't come good a evening. If it starts bad, it tends to end badly. And it's the same context here. When we're talking about applying the rules of evidence, we know that where evidence is improperly managed, whether it is by reference to the rules that were adopted or by reference to how they were applied, however good it is, we are as counsel, it may be extremely difficult to establish what the real position ought to have been and how the matter should best have been dealt with. So what we have to do here is to remember that since evidence is critical to the proceedings, we must at all times ensure, one, that we select appropriate rules of evidence and we ensure that they're properly applied. And in this context, the IBA rules recommend themselves because they have been around, are generally, as I said, ubiquitous in their application, and people tend to understand how they operate. Now, the other thing I like to say here, as we seek to select by way of just thinking of what happens here, is that while we again, I heard IBA mentioned, the fact that in India, for domestic arbitrations, there's this 12-month rule of trying to complete things within 12 months. Great objective to have. But again, even in relation to how evidence is looked at, we need to make haste slowly. Because time is money, yes, but haste can result in significant waste, including waste in a manner that could undermine the ultimate decision that is made. So we need to bear that firmly in mind. The other thing, of course, coming from the arena is to remember that we must learn the rules and sensibly apply them. I'm not going to read through the rules at this time, but the rules are fairly well set out if you go to them, and it's important to read them, look at how they apply, and where there are questions, just ask around, ask other persons who have applied them as to what they think about particular aspects of them so you can have a better idea. The other thing, of course, and to close out in this story from the arena, is to remember, I've said it before, but I'll restate it, that an enforceable award is the goal, and it is possible to win the battle and lose the war, including by reference to how evidence was managed in the proceedings. That is a critical thing to remember. Now, my final words are that the IBA rules, for all they are, for all their ills, are excellent rules when selected for the appropriate case. They are not rules that must invariably apply, but they are good to apply, and in international arbitration, they tend to be applied. But even in that context, we need to be mindful that even as we apply them, we must be mindful of the nuances in the particular case in how we treat with them. So the recommendation here, of course, as we go forward, what we're seeing happening is that more and more things are relying on technology in terms of how evidence is taken, in terms of how it is that information is stored and secured and all that sort of thing. Where it is available, we need to use it, because ultimately, the value of how we take evidence and manage it is in the cost value and how we act in a manner which is capable of reducing rather than causing that to balloon. So we need to make sure that we have that in mind. Now, there are questions, I'm sure, I'll certainly be happy to answer as we go, but the interest of time, has said that I probably spoke a few minutes too many. But what I want us to do as we think of evidence is not just to think of the nature, well, the content of the rules, but instead to think about it in a much more holistic way of what our objective is, and to be reminded that the objective is process efficiency, one, so as to secure an enforceable award, two, and in a manner where the parties can leave in their pursuit of justice, believing that the process served them well. Evidence is key. It is critical. It must be managed always with those things in mind. Thank you very much.
Thank you, Chris, for a very illuminating explanation, and also the opinions and also your thoughts on the taking of evidence and the processes itself. Now, the last segment is the question and answer. What we will do is we will let the participant to type in the chat box the questions. We can take it up one by one, as many as we could accommodate. Now, probably in the meanwhile, I can start the ball rolling by asking a few questions. I'm opening the floor to all the speakers. Let me just basically look at it generally. Now, Inba touched on it on the aspect of conflict. And of course, Dr. Malcom dealt with it in respect of the rules on taking evidence. And we are talking about the IBA guidelines. As we all know, the impetus for the IBA guideline is to bridge the gap between the common law and the civil law jurisdictions, where the perceptions concerning the taking of evidence and conflict rules differs. So the attempt was made to bridge the gap between both jurisdictions. And the next level of question is whether the IBA guidelines ought to be transposed into domestic laws, so that, at present, every institution has got its own guidelines concerning these two aspects. And every arbitration institutions invariably will have its own guidelines. So you have far too many guidelines. Is it possible to have just one working guideline for both conflict of interest as well as on evidence? I'd be happy to hear your thoughts, Aziz. Probably you can start.
Okay, my personal view is I don't think it should be incorporated into any domestic law. The reason, because everything's so fluid at this point of time. As we go along, changes, I mean, I'm sure the IBA themselves do realize that maybe in another, say, 3 or 5 years more, again, the different set of guidelines may come about in relation, or rather the kind of things that it should be incorporated within the checklist. So to put it in a form of a domestic legislation, I think is kind of, it's going to create a scenario where it's going to be quite static, and I think it's not practical. That's my personal take. I mean, I do not know about the others. Of course, India has such, like so we have heard from Mr. Inbavijayan that in India they've created this already. They've gone beyond IBA guidelines, but to what extent, I mean, it should be done like that. I mean, because I think there must be some fluidity, in this. So that's my personal. I mean,
Yeah, of course, we take it that there should be a flexibility, but probably we can hear from Imba. What's your thought on it?
It's very simple. During my presentation also, I just happened to share the overreach what the Indian legislature has made when it comes to these list systems or the guidelines. Having said that, the independence and impartiality obviously are the cornerstones of arbitration, and the type of tiered system what we are looking upon or discussing, that I think that obviously doesn't overlap. It might be better. It might be fitting the international community when it comes to the international arbitration. But since jurisdiction like India, where the statistic shows a larger number of arbitrations goes to ad hoc rather than the institutional, the cornerstones have to be cautiously taken upon, and unified list would also could enhance transparency, but at the same time, you can say it would lessen the flexibility which has been offered. That is, the significant factor of party autonomy right now, which has been provided in arbitration, might be a challenging one. And anyway, a robust system, no doubt, or a clarification in certain aspect of these lists might even stabilize the system. But we are in a jurisdiction, obviously, this IBA guidelines has been made mandatory for domestic. Not only that, it is also applicable for international arbitrations if it's been seated in India. And this happens to be reasonably understood to make the component of like a regional hub for international arbitration. No doubt this might be facilitating, but anyway, we have to just look upon how it is going to be interpreted by the courts.
Yeah, it's very interesting new development in India. I think the Justice Surya Kant of the Supreme Court is betting for India and also Turkey to become international hub. And there is also another interesting development where the Minister of Finance has basically given a circular to limit arbitrations domestically in India. So it's a rather interesting development from India. Probably we can hear from Dr. Malcom on that aspect.
Yeah, I think it's a funny one, eh? I think what probably should, not so much that they should ever be brought into national laws, because there's a problem there. But I think through the bar associations in respective countries, you could have them becoming more involved in how they can translate those guidelines into rules that may be applicable. Well, I'm not even sure applicable is the word. That could be made available for consideration in how things are dealt with. But I say that particularly for small jurisdictions, and sometimes, you know, the world is a small place, they say, together, but not quite. I'm going to mention, for example, Montserrat for the minute. And many persons here may not have heard about Montserrat. On a good day, Montserrat has a population of 4,000 people or thereabouts. Now, the idea of your not knowing every single person in Montserrat if you live there is almost preposterous. The idea of there not being some level of connection by family, by relationship, or for some other reason is beyond unthinkable, right? So I'm saying that, and that is why I'm saying, you know, with the rules as we have them, good as they may be, there are some sociocultural and other nuances that have to be considered. But I would say, however, hasten to add that in the context of international arbitration, if it is that Montserrat or anywhere else, which is to participate in terms of the seating and sort of arbitrations, then I think you have to become a lot more delocalized in your operations in terms of what you do. And so to that extent, you may find that the rules will be applicable in that context. And in reality, you may not need national laws because in many international arbitrations, certainly ones in which I have been involved, there's almost always, invariably almost, a default to using the IBA rules, unless there's good reason not to. So to that extent, I can't see the real value of taking it into national laws if we're considering international. And as I've said, for domestic, we have to be cautious because the nuances could be great from one country to another, and even within countries from one region to another or state to another.
Now, that's a rather interesting perspective because, you know, look, I mean, like Montserrat's case that you've said very correctly, it's very difficult to apply and to apply to the letter. Well, participants, if you have any questions, you may either put it in the chat box, or you could just basically raise your question, you raise your hands, and you can basically ask orally as well. So there's another question that I have. which is basically that, look, insofar as the rule of taking evidence, now in 2020, there was a further improvement in respect of remote hearing. Now, Chris spoke a lot about cutting down costs, and one of the issues that are often raised is costs of arbitration is on the upstick and on the increase. So the question that we may ask, given that there is already a guideline and is very extensive as well, could remote hearing be a default process? What's your thought on it? Chris?
If I may start there, and I want to start for a particular reason. And I'm going to say this with caution, but maybe true, that I almost like to think that there was a matter I was involved in during the COVID period that had significant implications for the LCIA rules being changed in relation to remote hearings. And I have no doubt. And I tell you what happened. There was a matter I was involved in. I was acting as lead counsel for the government of an entity from the government of St. Kitts on it. And in that proceeding, the seat of the arbitration was agreed. A Canadian company was in, Canadian entity was involved, and the Canadian government entity and the government of St. Kitts through one of its entities. And the seat of the arbitration was decided to be St. Kitts in a construction matter. And during the hearing, or at the point where we're about to get to the hearing, COVID, the implications of COVID impact. And of course, given the nature of the project and everything else, from the government side of St. Kitts, they did not wish to go to remote. And it created no ends of problems in the process. We ultimately agreed upon it being remote in terms of how it was managed. But the difficulty, as you would imagine, was this. The legal team that I led had lawyers from 3 different countries as part of my team, right? The team that acted for the Canadian entity was a Canadian firm, big Canadian firm with all of their lawyers in Canada, even though not in the same office. They were all able to turn up in Vancouver or wherever it is that they all gathered to do their matter. Now, as you'd imagine, it is one thing to have a situation where you're talking about remote, where persons are, and certainly the legal representatives are all in a common room and having access to their main witnesses available to them in a common space. It is another thing where, as happens in international arbitration, and it is not unusual, where you could have a diverse legal team with people from different jurisdictions. And in this case, the arbitrators were 3, one from Scotland, one from Canada, one from somewhere else, were involved in it. And although we defaulted there, and I think the matter went through fairly well, certainly from my side, we won, so I'm happy. But at the end of the day, what came out of that process was one where there was a tinkering with and doing all sorts of things, which I'm not sure was necessarily, given the circumstances, in the best interest of the arbitration, though it served the purposes because of where we were at. And invariably, you know, it didn't, from my client's side, it didn't reduce costs. What it meant is that my team still ended up traveling under severe restrictions into COVID, so much so that we got there. And while we were there, we were then put into isolation for literally for 2 weeks. We were in the same hotel in different rooms and not able to meet with each other, except by whatever, until that period ended. So much so that even food coming to my room and to the others of my counsel was put on a table outside our doors for us to get it. And then at one point, we even had to change rooms without the people coming in to change our linen, sort of thing. So we had to deal with those things. Was it in the best interest of the process and everything else? Certainly not. But it was an efficiency concern that we had to deal with. But I'm saying, as we take these approaches, which are invariably meant to deal with exigencies as they come up, there are sometimes which we forget that at the end of the day, there's a process, there's efficiency of the process, but there are the parties and their best interests to be served. So I am not so clear that I am one who want to say that we should jump to say that this invariably is what happens, because very often when people are making these rules, they are not thinking of the implications as I have just stated, and others which could be even worse. And in that process, quite frankly, we made us think about it. We did all sorts of things, big letters going through to the CIA and everything else. And it was subsequent to that that the rules were changed, which then allowed, because the rules, as you know, before that, said that the arbitration had to happen at a geographical place.
Right.
Under the LCIA, those rules have changed.
Right. So in other words, I mean, good as they are, it requires a lot more thought to it,
Indeed, indeed. That's the point.
Mhm.
right? Aziz,
Yeah.
you got any
Yeah, if I
take
can
on it?
jump in, if I can jump in. You see, I mean, I can understand where Dr. Malcolm was coming from, but I think he has to understand that during COVID, there was no I mean, no sort of, there was just absolutely no doubt that if one wanted a hearing, that was the only way, right? Remote. So I'm not, of course, I'm definitely not agreeable that hearings in future should be remote in a sense, and that should be in fact the default scenario. But one must bear in mind that if in fact parties want the hearing to be remote, maybe because to save costs. Example, if I'm say appointed for parties in Kigali itself, right? One is in Kigali because I'm on the panel there, and one is in Nigeria. And if they feel that they don't want to bear my cost to come there, and have to be, then I have to tell them, say, listen, to a certain extent, they will have to consider my flexible hours, because bearing in mind, Nigeria may be 8 hours. I mean, example, Kigali is 5 hours behind. Nigeria could be about 7, 8. So okay, I don't mind doing some hearings, say maybe in the nights in that sense, but up to a certain time, or maybe mornings, and they have to come back. I mean, they will probably be early morning hours there, or even in the nights. But what I'm saying is that it is something that they have to consider in that sense. But it cannot be a scenario that, just because things have changed now, that should be the default scenario. So to me, hearings in person will definitely be better. All right. And especially, of course, if the parties have agreed to the appointment of the particular person as an arbitrator, they must agree to bear certain amount of costs.
Right.
So that
So
the hearings can take place
Aziz is
in person.
betting for obviously a physical hearing. It's
No,
more
yeah, I mean,
physical person.
unless of course the parties really want it,
Mm.
then I think you have no choice. Unless you want to have a situation where you said, okay, you're not prepared to accept the appointment, then fine. But I think, see, the way I can understand the way you were asking is whether this should be the default.
Right.
That one I don't agree with.
No,
Okay, so
obviously,
that's
thank
my,
you. Right.
yeah.
Okay, that's your thought. Inba, any thoughts on it?
Dato, I have to go along with Aziz. It's likely to be like 2:1 or 3:0. The new normal is past.
Right.
Whatever has been taught in COVID has to be relooked, because as arbitrator, when we are just dealing with these examination of witnesses, particularly on the expert witness, when we are handling the volumes of papers, which anyway, the technology is there, which is the fourth eye of the arbitration. But still, the traditional way of having the physical hearing, particularly when it comes to these expert witnesses, no doubt, it can't be a default as put forward by Dato. It might be a preferred. It can be a preferred mode for arbitrations when it comes to institutional arbitration, wherein if we have a effective virtual hearing guidelines after the COVID situation, we do have many institutions like what Dr. Christopher was highlighting, the LCA rules, the development of LCA rules. We do have the virtual hearing guidelines, but we, as arbitrators, we can have it as a preferred, subject to the parties' consent. It can't be a default. That's my humble opinion on this.
Right. So
In fact, many,
it's
sorry,
not
many institutions have
it
such
is an
rules.
exception rather than the rule.
Yeah.
Can we agree
Yeah,
on
and
that?
if I may, if I may, Chair, just to confirm my position, I am not suggesting that at all, and I don't think that point was taken that I'm saying that you cannot have remote hearings. I'm suggesting that it should not be the default one, and I'm also saying that when it is implemented, there needs to be clear decisions taken bearing in mind what the circumstances are and how best to manage it. In my particular instance, and I've made think publicly about it, it's just the manner in which it was handled that mattered. And the fact that I think in that case, the parties felt, certainly my clients, that they were not given the best opportunity, given the nature of the project and given all the other things that flowed from it. So and I understand that that was the only way at the time hearings would have happened, but I go something to say this to Aziz, to say this, the fact that my team could have got there, other people could have as well. I could say that. So that's a different story. People took certain decisions that they didn't want to travel and so on. And generally speaking, I did not travel at all during the COVID period. I simply stayed at home. But the fact is that we need to remember that as we're thinking about cost, there is a value to people being in front of you. There is a value to being able to look at a site rather than send a drone over it. There's a difference. You will never get a drone image on a construction project being the same as however good the drone operators are, being the same as you're being able to physically look at the concrete and look at the steelworks and all the other things that are there. If it's a bridge or a marine works, take something, a boat, go under it, look at it. And so the drones will never be able to give you the site that you require. So we again have to be mindful as we're thinking about remote as being default, particularly where it's not emergency situations such as COVID. We have to think, yes, there may be cost implications, but in the overall scheme, are we sacrificing the pursuit of justice? Going back to that first line of text and management, in the interest of establishing rules for efficiency in and out of courts, without understanding that there's a more inherent matter that we need to be concerned about, which is the effective pursuit of justice.
Yeah, Aziz, you wanted to say something?
No, I was just going to say that, basically, I think most institutions have their rules now, which was crafted during the COVID, and some have still kept it. But COVID was COVID. First of all, I think to answer Dr. Malcom, none of us could travel anyway. I mean, because if you travel, that's it, you can't come back. So none of us could travel, I mean, in the sense of the word. But the situation is different, But in any way, like I said, I mean, if I have to go through a hearing, as far as Zoom is concerned, I have to accept it, provided I'm willing to accept it, and provided, of course, the parties agree to certain permutations in terms of timing and all, depending on the jurisdictions where they are. That's my take.
Right. Okay, thank you very much. I think we have, I think, exceeded our allocated time, unless there is a last minute questions, of which I don't see anything in the chat box. Anything oral
Can I
questions?
just raise something?
Yeah, sure. Yeah, sure.
Basically, I was sort of, when I was highlighting in my slides certain things, I mean, I just wanted to know whether anyone here has got any, I mean, amongst the participants especially, I mean, about what I felt should not even be there. It should be, in fact, in a non-waivable of provided it should be still in the red list rather than orange. I mean, any thoughts on anyone or from anyone? I mean, because everybody is so quiet. Because I thought I was trying to sort of, excite people and, start people thinking about this. And that's why.
It's very difficult to get anybody excited, especially during dinner time. The only thing that they get excited about is food. Unless you're offering food, I think there is no excitement that I could actually see. Probably they could basically, you've gotten your email. Probably they can basically do it offline if they are, as is usual. The culture is not to raise questions, face to face.
Sure.
That's the great problem that we have. If anybody who want to basically in the last minute, in the last seconds, want to say anything?
Can I add, actually, I do agree with Aziz's point about there's one line in the orange list that should be in the waivable red list or the non-waivable red list, particularly a law firm or other legal organization that shares significant fees or other revenues with the arbitrator's law firm.
So you only see one. I see more than that.
I've
Okay,
seen,
doesn't
I've
matter, but
seen,
which is fair enough.
I've been
Okay,
in an
great.
arbitration where it has happened. So
Okay.
I feel that even though he was still able to stay as an arbitrator in that arbitration, but there's still some I
Yeah.
think the opponent wasn't too happy about it. So I do
Okay.
think that there are some things that
Yeah. You see,
can
because if it's an institution-based arbitration, I mean institution-led, then of course, even if challenges can be, I mean, can be overruled by the institution question, in concern.
I mean,
So
there are challenge
yeah,
procedures for that.
yeah,
I
correct. But
suppose that,
despite that,
I mean,
yeah,
the
correct.
only thing that the arbitrator will do is waive the IBA guidelines and say that, I'm in the clear.
Yeah. No, but I
Right.
think I always personally feel that if there's really a challenge, and if the person sees that the grounds of the challenge are quite valid, he or she, I mean, meaning the arbitrator concerned, should just say, okay, listen, forget about don't talk about the challenge anymore. I'm going to withdraw. I mean, as a right thinking person, you see, trouble is there's so many arbitrators only thinking that because they've got that piece of job, they want to hold on to it, die kind of scenario. I mean, so that's wrong also.
It depends on the arbitrator at the end of the day, right? So, any other questions that we could entertain in the last minute?
so I mean, wouldn't it also look bad on the arbitrator when later on, even if he chooses to accept and that award is set aside because he chooses not to, because the
I
challenge
think
application is
looking back is not the question. The question is obviously at the end of the day
Yeah.
whether principally, as a matter of principles, there is a conflict, and
There is a
obviously,
question,
yeah. Sorry,
Shukor,
go ahead.
sorry.
Yeah.
There is a question from one Mr. Gopalakrishnan. I have a question. What is what is it if arbitrator or what is arbitrator? Maybe I'm saying if. What if arbitrator name in the arbitration agreement falls in the red list? Can he accept appointment?
he has to
What do you mean
decline,
by
right?
name?
The
Yeah, so what do you mean by
revocable one.
named in the arbitration agreement? Can Mr. Gopalakrishnan actually explain the question? Can he unmute? I'm trying to understand the question. I think, of course, it's not is, but if. What if an arbitrator named in arbitration agreement? Yeah,
Can you hear me? This is Prabhakaran.
sure.
Yes. Go ahead, Prabha.
Yeah, my question is, I have come across an arbitration agreement where the arbitrator is named in the agreement, so and so Mr. is named, and he is actually a manager in one of the parties' organization, but he's named in the agreement. So, can he accept the appointment?
Frankly speaking, he should not, because that would be one simple ground for the other party especially, to be able to, I mean, especially if they say that party is a losing party, to be able to raise it to set aside the arbitration award.
But
And I think it will be, sorry, it will be, in my personal view, it will be foolish of that person to actually carry on accepting the appointment.
even though he's named in the agreement and the other
Yeah,
party
I
did
mean,
not
it
object.
doesn't, yeah, of course, when you say there's an economic, I mean, especially there's, some kind of a financial connection there, it's very dangerous, And in
Okay.
fact, the other side can always raise an objection. And if it's institution, of course, they can put in this challenge to the arbitrator
I'm
concerned.
fairly certain that this is not an institution-based appointment. It's
Well, let's
very
assume
rare.
even,
Yeah, it's
even
very
if so
rare.
if it's ad hoc, then
Yeah.
it should be made very clear to the arbitrator that I'm challenging your appointment, you should not accept it. And of course, once you warn like that, I mean, the possibility is that the award may go against say you're the counsel or you're against your client, then you can use it at the end of the day to be able to set aside. Because, I mean, it's quite obvious, I mean, in my personal view, that when you say he's a manager and a kind of thing, all that. So what, even if he's named? He can always, okay, of course, he can then say, I maybe should nominate so and so. But then the question is whether that person then should make a disclosure. What are his interests, or whether he's connected to that parties concerned. I mean, sorry, to the parties concerned. I mean, it's a very, it's very difficult to sort of give a definite answer. But I think this kind of scenario that you just raised is definitely a red flag, a non-waivable kind of thing.
Aziz, I'm going to raise a question, not for you to answer now, but for you to think about. You know that there's provision under the model law which you apply, and which many of our rules apply, yes? That allows for remittal in certain circumstances for where there's a challenge to set aside. A matter may be remitted to an arbitrator to consider whether or not the award can be upheld, right? In substance, if, however, the matter is being remitted where the substantive basis, improperly in my view, but let us say it has been done, in circumstances where the substantive question is along the line that the arbitrator, for example, did not give a party a proper opportunity to be heard. Let's just consider that for the minute. And it comes back on remittal. Is there a critical conflicts of interest question arising, notwithstanding that the court has referred it back, right? That should then cause an arbitrator to recuse himself from even hearing what the court has remitted on the basis that this will now put me in a position, because I will now in substance be treating with almost an appeal of my award or a challenge to my award. Is that a conflicts of interest situation that must be dealt with? I have my views on it. In fact, I have a matter now that I'm dealing with where that very question has arisen. But I think it raises, and in fact, it's something which I think in the model law, as I mentioned it, because and many of us have applied the model law, it's a question that needs greater clarity as to the circumstances in which remittal should not even be a question.
In a way, it goes to integrity of the person concerned, right? I mean, that person, should actually not be willing to accept that completely. I mean, it's to me, it's quite clear. Like I said, but you see, trouble is, people in different jurisdictions. I mean, maybe the way we are raised, because Singapore being so international, we've got a center here, which, and as you know, Singapore is, SIC is like really just pressing on. They're trying to be as international as they can be. And we have been trained within that scope, you must understand. So basically, that's how it is. So, I don't know. Different jurisdictions may have different views about this. Of course, it is for the arbitrator himself is be able to decide, say, whether I can or cannot, say, proceed. But it will be foolish of him to carry on and say, I want to accept it. So, this is, it's all very personal. So, but I think it's a very dangerous situation in scenarios like that for him to carry on.
Well, exactly. I think much as it is personal, we must accept also that as far as IBA is concerned, it provides a general guidelines. It's not possible to cater to all circumstances and all that. At the end of the day, like Chris says, obviously, even on specific situations, obviously, much thought is required to be given to that fact situation to come to a landing as to whether a recusal ought to happen or ought not to happen. Okay. Any other questions that we may have? I don't see anything on the chat box.
I hope we've answered this, Mr. Gopalakrishna's question.
Yeah, it's rather peculiar situation. You don't see that that in international arbitration scenario where both parties has actually named the arbitrator. It's it's an exception rather than rule. If there is no further questions, what is left for me to do is again to thank all the speakers for their time and for their intellect. I have certainly benefited from their wealth of knowledge and experience. I thank them personally from the bottom of my heart. And I shall now give it back to the organizer to do the closing. Thank you very much. Thank you very much, participant, for being a good sport. Thank you.
Thank you, Dr. Shukor.
Thank you, Mr. Aziz, Dato Shukor, Mr. Imba, and Dr. Christopher. I think everybody has a lot of homework to do to go and read the IBA rules after this talk. And I especially enjoyed having a refresher on how it is like and how the rules apply in arbitration. Look forward to our next BicTok coming up soon. Next month, it will be on CIDB contracts. So we'll have the technical committee speakers sharing their experience when they were drafting the revised contracts. So thank you again, everyone. Enjoy your dinner.
Bye-bye. Have a good day.
Yes, goodbye. Thank you.
Bye.
Thank you, Chris.
everyone.
Thank you, Inba. Thank you,
Take care. Have a
Aziz.
wonderful
Thank
one.
you.
Thank you, Dato.
Goodbye. Goodbye.
See you soon, huh, Sharifah?
Yes, soon, soon. If you're coming over, Inba, Chris, to this side of the world,
Yeah.
let us know. We will buy you a good food.
I
By the way,
certainly will.
Dato, I should be in KL soon also.
Same,
All
same.
right. You've got my number.
Sure.
Yes,
We'll have
we
lunch or
do.
dinner, whatever. Okay.
All right. Okay.
Great. Take care.
Cheers. Take care.
Cheers.
Yeah,
Cheers.
bye-bye. Bye-bye.
Good night,
Bye-bye.
everyone.